All right, good afternoon. It is August 12th, 2020. Welcome to this week's edition of Ask a Lawyer. Thank you for joining me, anyone who is joined already. And the more astute of you will notice that I am not Gary Berger. Gary's on vacation this week. My name is Tyler Thompson. I am filling in for Gary, and we're going to go through a series of questions and topics that people are interested in talking about. First thing I wanted to talk about a little bit. Hi, Adam. First thing I wanted to talk about a little bit what is underinsured motorist coverage, which is something that many people have and maybe don't know they have it, or people may not have it and don't realize that they probably do want to have it. It comes up in the context of your auto insurance. Policies in the state of Missouri require uninsured motorist coverage, which means that if you are in a motor vehicle accident with somebody who does not have insurance of any kind, or if their insurance denies coverage to them, you will recover actually against your own insurance company, and that's uninsured motorist coverage. And it's actually mandated that policies in the state of Missouri require at least $25,000 worth of uninsured motorist coverage. Underinsured motorist coverage is basically sometimes described as gap coverage. And so, for example, if you have a $100,000 auto policy and you are in an accident with somebody who only has $25,000 worth of insurance, they will, and if they cause a serious injury to you, your claim may be worth more than that $25,000. So you are entitled to recover against their insurance for the limit of their policy of $25,000, and you have to exhaust their policy, meaning you have to use up their entire policy limit under their policy, and then you can go and ask your insurance company for underinsured motorist coverage to make up the difference between that $25,000 and the $100,000 available to you under your policy. There are certain offsets that apply to that under certain circumstances, and there are certain situations where you don't necessarily need to require the entire $25,000 yourself. For example, if 3 people are hurt in the accident and you divide the policy up, 10, 10, and 5, even though you've only got the $10,000, because that entire $25,000 was used up, you're entitled then to get underinsured motorist coverage. But it's not required in the state of Missouri. Your insurance company does not have to sell it to you, but I would highly recommend that you purchase it. It's not a huge expense added on to your auto coverage, and it protects you in the event that you are injured by somebody who has a minimum policy or has a policy that has a limit less than yours. So if you have $250,000 and they have $100,000, that provides you that additional protection, usually only up to the limit of what yours is. So you're not able to recover your full policy and their full policy, but you are able to recover the amount up to your policy. It basically replaces it so that you would recover what you would otherwise be entitled to anyway. All right, Adam, we've got a few questions coming in. Adam first asks, how do privacy requirements impact your work day to day? Can you use things like email for case-related communication? Privacy is always a concern, especially with lawsuits and attorney-client representation. And so it does impact us day to day. We absolutely can use email, we can use text, you can use any means to contact your client that will allow protections. And the language I believe that's used is reasonable protections. And so you have to have a reasonable expectation that their communication will be secure. So, for example, don't if you're trying to talk to your attorney, don't ask them a question and put it up on a billboard. Don't ask an attorney-client privilege question during a Facebook Live show. But you can use email, yes, and we take precautions with our email. We take precautions with our system to make sure things are secure. For most lawsuits, the greatest impact that results on us from privacy protection are the HIPAA laws, which are related to healthcare, and that often there are certain hoops that we have to jump through in order to obtain medical records, for instance, or we will have our clients obtain their own medical records from their doctors and then provide them to us in order to make sure that HIPAA continues to protect them, because hospitals are very wary of HIPAA violations. It's something that can cause them problems and can result potentially in pretty significant penalties for hospitals if they violate HIPAA. So that's something we have to deal with. But as far as client communication, usually we go with whatever the client's preference is. Some of our clients prefer written letters and getting them in the mail, and with those clients we go that route. We will go phone calls, but a lot of our clients now often prefer text or email, and those are available to us as well. All right, Jennifer, thanks for the compliment about the tie. I appreciate it. And if you get into a car accident and only have an emergency room visit and a follow-up with my primary care doctor, do I need the help of an attorney to settle my claim? My answer to that would be sometimes. It depends on the case. If it's a situation where you've got an emergency room visit and a follow-up and then a nagging ongoing problem, you've got something wrong in your shoulder that your primary care doctor hasn't yet taken a look at, but you think it might be something more serious, that's the kind of situation where you would want to at least consult with an attorney. And for example, our initial consultation in cases like that is absolutely free. You can reach out and contact us at any time, and we will talk to you about that. If it's a situation where you went to the emergency room as a precautionary measure, you went to your primary care doctor, and that doctor took a look at you, and he or she said that you're doing just fine, there's no residual problems. I actually had this myself. I got rear-ended. I went to an urgent care immediately afterward, just out of precaution, and I went to my primary care doctor, and then after that I felt absolutely fine. And under those circumstances, you are often able to resolve it yourself. And you're often better off doing that under those circumstances because the cost of retaining an attorney doesn't increase the difference in what you would potentially be able to recover from their insurance policy. And so if you're looking simply to get your initial hospital bill taken care of and your primary care doctor taken care of so that you're not out of pocket anything, or if you want the property damage on your car taken care of, that's often something that we advise people to handle yourself because you're better off doing that. When it's more complicated, the more significant an injury, the more significant the damage to the car, the more likely you are going to at least want to have an initial consultation with an attorney and then potentially talk about representation if you do have something that is severe and an ongoing problem. Another question coming in from Kelly. I was almost bumped by a car yesterday when someone was pulling out of a parking spot in an Aldi parking lot. If they had made contact at all with me, should I have gotten their insurance information, even just a bump? Does an injury have to be bad in order to bring a claim? Thank you for the question, Kelly. I am glad to hear that you are okay and that you didn't, in fact, get hit in the Aldi parking lot by a car. And my recommendation would be, if they make any kind of contact with you, though, that yes, you do want their insurance information, potentially their license plate. You do not want to be in a situation where you do not have that information if, for example, you initially think that you're fine. You will probably have some adrenaline going as a result of a situation like that. You'll get knocked down. You may jump up and feel absolutely fine at that point in time. You may go home then and realize that something is wrong with your shoulder, something's wrong with your elbow, something's wrong with your wrist. And if that is the case, if you have their contact information, you are able to make a claim against their insurance. If you don't have that contact information and you have no idea who that individual is or how to identify them or how to identify any insurance they might have, the claim you have to make is against your own insurance company. And what I led the show off with is uninsured motorist coverage, and that would be an uninsured motorist claim. The problem you run into with making an uninsured motorist claim against your own insurance company is that you're making a claim against your own insurance, and that can often impact your rate. And so because it's the other person's fault for backing you over or however severely they hit you, you want it to be against their insurance and not against your insurance, because it wasn't your fault at all. You were doing exactly what you're supposed to be doing at the time, walking in a parking lot, and you obviously need to keep an eye out for your own safety doing that, but they also need to be looking out for you also. So my recommendation would be, yes, even if it's very, very minor, exchange insurance information. If there's property damage at all or any kind of question like that, I would also recommend calling the police in order to have them come to the scene, take a police report down, and that offers you an additional layer of protection with the police having the opportunity to investigate the accident. Okay, a question from Maya. My car was once scraped by another car while I was parked downtown. They were gone by the time I got back to my car. Is filing with my own insurance provider the only option for a case like that? Normally, yes. If there's a situation like that where you are completely unable to identify anyone who would be at fault for this property damage, the recommendation would be to contact your own insurance company. It's not ideal. It's unfortunate that they were basically rude and didn't leave a note about the damage that occurred to your car. Making the best assumptions about people, they may not have realized that the damage happened. They may not have realized they made contact with your car. They may have thought they made contact with a wall or something else, to ascribe the best motivations to people. But sometimes people just simply, they back into your car and damage it and then just take off. And unfortunately, if you make a claim against your insurance, it may impact your rate. And that may be the situation where you may want to look at your deductible. You may want to decide if you can live with the damage, if you want to pay out of pocket for it. That might be your best option. It might be your best option to pay the deductible and have your insurance company handle it. But those are kind of your best choices at that point in time. Would be my recommendation for that. Some other questions that I got prior to getting on here live, actually. One is a little bit off topic with respect to the law, but somewhat applicable given her prior profession. But got a question related to Biden's VP selection yesterday. What do I think about it? It's an interesting choice, and this allows me, I guess, an opportunity to talk a little bit about what I kind of really want to talk about, which you'll see in depositions, and you'll see with politicians very often when they're being interviewed that they'll use a question to talk about what they're really interested in talking about. But my interest in talking about Kamala Harris is her prior career as a prosecutor. I think is potentially valuable for a politician to have that kind of hands-on experience. As far as the selection of her for VP, my lay person's understanding of VP selection is that your goal is to pick someone who is going to get you elected, or at least help get you elected. And I don't know that she's going to move the needle on that the way that people want her to. She's from California, and you often are interested in picking somebody who either shores up weaknesses that you have or can bring you a state that you wouldn't otherwise win. I don't think anyone in the world questions that Joe Biden is going to win California. And so I don't know if it helps him in that respect. I know she has some attacks on him, which is very common in a disputed primary, such as this one. And Tulsi Gabbard had some attacks on Kamala Harris that I think could potentially cause problems during the campaign. So from a pure political standpoint, I don't know how effective a choice it is. And then one of the things that I wanted to sort of actually talk about this is problems really, I think, with the criminal justice system in the United States. And I don't think it's uniquely Kamala Harris that has these kinds of issues in her past as a prosecutor. But there are situations that I have read about, and Tulsi Gabbard actually brought several of these up during the primary debates related to treatment of evidence and treatment of prisoners, and what she, or at least what her office did as Attorney General, I think raises some very valid questions about treatment of people in our criminal justice system. And I think it's a larger issue in the United States with prosecution. More than 95% of cases overall, including civil cases, settle before trial. More than 95%, I think it's closer to 99% of criminal prosecutions are decided by plea bargain. And I just, quite frankly, personally, I think that's wrong. I recognize that it's a limit of the system and there are limited resources to try these number of cases, and that defendants are often better off taking a plea because they will be, for example, you get a plea deal offered of 3 years, maybe 5 years, and the total charges, if you were convicted on all charges, would result in 40 years in prison. I'm 38 years old right now, and I can tell you that if the police walk in right now and arrest me for a crime and charge me with something that I can potentially be put away for 40 years, even if I have nothing whatsoever to do with it, and they offer me 3, I'm going to take the 3, because in that case, I'll get out at 41 and I can watch my children grow up, rather than spending the next 40 years in prison, because you can appeal, and there are other opportunities, there are other avenues, but you basically get one shot at a trial with 12 individuals that you don't know that are going to decide your fate. And that's a lot to hang the next 40 years on. And so I think that's more emblematic of the larger problem in the United States with the way that the prosecution system works. Okay, back to more lawyer-oriented questions. Davey Herr asks, what's the difference between an attorney and a lawyer? I always thought they were synonyms, but an episode of Silicon Valley said differently. Davey, I'm sorry to say that I have not seen that show. I hear great things. I hear it's extremely funny. To my knowledge, there's actually no difference. Usually when I introduce myself to people, I say I'm an attorney. When I'm being self-deprecating, I say I'm a lawyer. When I'm being really self-deprecating, I say I'm a shark. But it's more just an interchangeable terminology. The difference that they may have been alluding to is, for example, in England, there are barristers and there are solicitors. And that's, from my understanding, obviously I'm not licensed in the UK, full disclosure, to practice law, but my understanding of that is that there are differences between those, even though they are both more formally legal trained than, for example, attorneys and paralegals. Paralegals do not have to go to law school. My understanding is solicitors do have to go to law school, and they're the ones that actually do more of the investigatory work, and a lot of what we would think of as the work that paralegals do, and that the barristers are then actually the ones that appear in court and argue the cases like you see on TV. But to the best of my knowledge, there's not anything different at all, despite what Silicon Valley may represent to you. Rob Kroll, now that the Missouri Department of Corrections lawsuit is in the hands of the Missouri Supreme Court, still waiting on a response, is the 9% interest still accruing while we're waiting on them to hand down the ruling? It's an excellent question, Rob. My understanding of that is that, yes, the interest continues to accrue while it's pending in front of the Missouri Supreme Court. Unfortunately, they, under the best of circumstances, appellate courts move really slowly with respect to appeals, oral arguments, and so forth. And obviously, with COVID going on, that impacts that and makes it even slower than it otherwise would be. So, to the best of my knowledge, that does continue to accrue during this present point in time. Maya, what is one thing you feel another country does better than the U.S. regarding the legal system? That's an excellent question, and it's one that's tough. I don't know. Obviously, I've never practiced anywhere else. I've never practiced in, say, Canada. I've never practiced in the UK. I've never practiced in Japan or Korea or any place else. One difference I will say between the U.S. system and other systems is that in many other countries, the prevailing party, meaning the party that wins a trial, automatically gets their attorney's fees paid for. That is not the case in the U.S. system. I believe the United Kingdom is a country where that is the case, and there are a number of countries in Europe where that is the case. I'll say about that there are pros and cons for both. The argument to make sure that you get your fees paid for is obviously you had to bring suit. You had to go through the whole painful process. You had to hire an attorney like me. You have to go through, you have to fight it all out, and then you go to court, and it seems like you should be able to make the other side pay for your attorney if you were in fact right on the issue. So from that standpoint, it seems like that would be fair. I will say about that, the limitation is it allows, for example, large corporations, billionaires, even millionaires, people with lots of money or lots more resources than the other party, to protect themselves simply by hiring very, very, very expensive attorneys. And so, for example, if I want to sue Ford Motor Company, Ford Motor Company can afford many more attorneys than I can, and they can afford much more expensive attorneys than I can. And it would, if I run the risk of having to pay Ford's legal bill at the end, I know that they're going to go out and they're going to hire some firm that charges $1,200 an hour, and they're going to have them do everything they can under the sun to spend as much money possible under the case so that if they win, they can stick me with the bill. And in a lot of cases, that would prevent me from filing suit entirely, even if I have a very valid claim. So it's one of those situations where it often comes down to trying to balance the interests, and where do you decide that balance lies? And I happen to think that despite the limitations of the legal system in the United States, that's on balance a better system. And there are exceptions here related to that. One of those exceptions, for example, is civil rights claims. You're often able to get the other side to pay for your attorney because they violated your civil rights. And there are certain other circumstances where that's the case, but under most circumstances, each side foots the bill for their own attorney. Brennan, what attracts lawyers to certain areas of law like personal injury, criminal defense, prosecution, corporate tax law? Is their personality type or common skill set? Good question, Brennan. I think it's very often it comes down to personality. It comes down to some extent whether you're an introvert or an extrovert. People that are very extroverted often tend to lean toward litigation because they appear in court, you stand in front of a jury, you argue your case and all that sort of thing. And there are people that are very uncomfortable with public speaking, that are more what you would describe as classically introverted, that are more comfortable doing contract work, doing real estate work, doing some of the more kind of behind the scenes work that you need an attorney for, where they don't have to go into court and argue. And then some of it just depends also on your other skill sets that you have. For example, tax law is very math intensive, so people that might also have an accounting background will be more prone to go into a field like that. I am personally very bad with numbers. I was terrible at financial transactions in law school, and so here I am doing personal injury work. So it kind of depends, and there are always exceptions to every rule, but that's often some of the considerations that go in. Kamala Harris's background as a prosecutor help her in a potential vice presidency role. Also, not any lawyer, but as a Black/Asian/female lawyer. I possibly. I think being a prosecutor can help, as I alluded to before, that kind of hands-on experience when you're working, and for example, the executive branch is charged with enforcing the laws. Congress theoretically writes the laws, the executive branch enforces the law. And so that kind of experience gives her a leg up. You know, her background being from, my understanding is one of her parents is Jamaican, and I think the other one is from India originally. So obviously it brings a different perspective on things. It certainly brings a much different perspective than Joe Biden has had. And so I think that's an advantage to her. As far as discharging the role of the vice president, it's officially just to break ties in the Senate. So if they come down 50-50, she gets to pick one or the other. That individual role, that's the only prescribed role for the vice president in the Constitution. I don't think really you need anything to help with that, aside from the ability to decide one way or the other on an individual particular issue. But obviously there are a lot of other things that vice presidents do. They're often a face of the presidency. During campaigns, they're often referred to as an attack dog. They're often the ones that are charged with going after somebody. I think in this particular circumstance, she'll probably be able to do very well in that role against Donald Trump. It'll be sort of interesting to see how that plays out and to what extent they use her as the face of the campaign, given COVID and some of the other limitations that have taken place. So that will be interesting to see. And if they end up winning the role, it'll be interesting to see what she does as vice president, and then potentially as president someday. So I guess we'll have to kind of table that and see in some point in time. Adam, what advantages does a large injury law firm have over a small one? It again goes to it just really depends. It's certain firms really, though, even no matter how large a firm is, your case is going to be handled by an individual attorney or a small team of attorneys that are going to head up the case. Large firms have more associates, and so that saves the partner some time in being able to delegate more work. But ultimately, you're not hiring a firm to represent you in court. You're hiring an attorney to represent you in court. And for example, your trial team is going to be one attorney that argues to the jury, maybe two that argue to the jury, and that's really going to be the extent of it. And so they do have some resources that provide them some individual advantages really for their own personal benefit. If that partner has an associate that he can dump something on a Friday night so that it doesn't ruin his weekend or her weekend, the partner may well do that. So that'll help them out, but that doesn't necessarily help you out. And really what you want to do when you are hiring attorneys, you want to make sure that you hire an attorney that you are comfortable with, and you want to have an individual relationship with that attorney, because ultimately that person is going to be the person potentially appearing in court, arguing your case, giving a closing argument. And if it's somebody that you trust and feel comfortable with, you're going to feel more comfortable throughout the entire process, and you are going to do better. Because, for example, if you have to be a witness and you trust the attorney that's preparing you and then talking to you while you're on the stand and telling your story in front of the jury, you're going to do a better job representing yourself on your own behalf. Because no matter what I do to help you win your case and to help you be in a position to best present it to the jury, ultimately it is your case presented to the jury, and you have ownership of it. And so you need to be comfortable and you need to feel confident going in that they're going to be representing you. Does the size of the law firm determine the attorney's fee amount if a case is won or settled? Also, are attorney's fees regulated, or can an attorney law firm charge whatever they want? I am presuming you are asking about this from the plaintiff's side. In case you're asking about the defense side, I will say that yes, the size of the law firm very often determines the attorney's fees. On the defense side, attorneys bill by the hour under most circumstances. Sometimes they will take what is called a flat rate, meaning that they will agree to provide a certain amount of legal services for a set dollar amount. Those kinds of arrangements used to be exceedingly rare. They're becoming a little bit more common, but very often you're paying them by the hour. And a small firm, you're going to be paying less, and a larger firm, you're going to be paying more. Some of the biggest New York firms charge over $1,000 an hour. And I think there are a few partners in St. Louis that charge somewhere in that range. Over $1,000 an hour for their time, which if you break it down, 6 minutes of their time costs you more than $100. On the plaintiff's side, the way that almost all plaintiffs work and the way that we work is we do not get paid unless you get paid, meaning that unless we go to trial and win for you and secure money, or we secure a settlement in your favor, we don't charge you anything at all. We just take a portion of what we are able to recover for you. And for example, here at Burger Law, no matter how large we're going to become, that's going to be the rule, is that we are going to represent you for a portion of what recovery you would have. And it will not impact the overall percentage of the fee. Under most cases, we charge a third of the recovery, and then sometimes it depends when we get close to trial or if we go all the way through trial, because there is an additional risk in proceeding to trial and significant amount of additional work and expense in proceeding through trial. That goes up, but that number does not change based on the number of attorneys we have working on your case. And if you don't get anything, we don't get anything. Brennan tells me that I said I was bad at math. That was pretty quick. I'm quick enough to do simple percentages in my head. Financial transactions playing out interest over long periods of time, I am not great at. So for example, the question about the 9% interest earlier, I can tell you what 9% interest is. If you're asking me to put together an investment vehicle and compound that over time, I'm going to want to talk to either a financial advisor or an accountant. Okay, well, another general type question that I was asked prior to getting on here is, how do Gary and I work together, or how do lawyers generally work together? Describe your roles in working up a case. How do paralegals fit? I'm a client who works on my case. That's a great question. Some of that depends on the firm. Some of it depends on the personality. Gary and I'd like to say, work very well together. We get along. We communicate well. And it depends on the individual case. Gary's been practicing longer than I have. Gary's more experienced than I am. So the more complicated a case, the larger Gary's involvement is going to be. And if you want to think about it, if you want to use probably what is a mixed metaphor sports analogy, Gary under a lot of circumstances would be the coach, or perhaps our player coach, and I would be under those circumstances maybe the quarterback. In that Gary designs the game plan and we communicate throughout. Even quarterbacks that have a tremendous amount of leeway, the Peyton Mannings of the world, the Tom Bradys of the world, they talk to their coach constantly. It's not like the coach just puts together a package before the game and then hands it over and asks the quarterback to execute it. There's constant communication that goes on. And the paralegal's job is essential. Really, it's helping the nuts and bolts of the lawsuit move forward. And so their job is to assist with all of the things that allow to continue running with the metaphor, that allow the coach and the quarterback to do their jobs. And so if you want to think of if the paralegal as maybe the other players on the field, or if they're not the players on the field, they would be running basically everything else. They're the ones that would be getting, they'd be getting the supplies for the team. They'd be making sure that the team has the equipment they need. They'd be getting sure that the team has the tools that they need. They'd be making sure that the team has a practice space. They're the ones that help us do the day-to-day kinds of things to make sure that we don't have to do it. And if you're lucky and have a very good one, then it makes your job as an attorney a lot easier. And it's quite frankly, it's much appreciated. Adam Houston, what is a Brady violation? How often does something like that come up in general? I'm glad you asked this. This goes back to my little tirade about prosecutors earlier. Brady violation is what occurs when a prosecutor fails to hand over what's called exculpatory evidence to a defendant, meaning evidence that tends to show the defendant didn't do it. Probably the most famous example of this is Mike Nifong, who was the prosecutor in the Duke rape case that happened a number of years ago. Mike Nifong actually had DNA evidence that suggested that the Duke lacrosse players did not rape the woman that accused them of rape, and sat on it, I think, for more than a year. And I don't remember how it came about that it was found, but that's a Brady violation. He had something that tended to show the defendants were innocent, and he deliberately failed to disclose it. It's extremely serious. It's not something that comes up in civil litigation, obviously, because it's different for criminals. There's a different duty involved in civil discovery versus criminal discovery. Mike Nifong was actually disbarred as a result of his actions. I think that was entirely appropriate. Quite frankly, he probably should have gone to jail as well, because it's extraordinarily important. The criminal justice system and the civil justice system, in a lot of ways, functions on trust. And if there's not trust in the system, it causes all kinds of other problems, as I think is being demonstrated on kind of a daily basis throughout the United States right now. And so when a prosecutor abuses the trust in that fashion, I think that there should be extremely harsh penalties for prosecutors like that. I'm glad Mike Nifong was disbarred. I think that was kind of an embarrassment to his profession. I don't know why it was that he decided to hide that evidence, but somebody that's charged with putting people in prison and depriving them of their freedom should not do things like that, to say the least. Maya, what would your superhero name be, and what kind of powers would you have? Um, that's a fun question. Not entirely sure you need an attorney to answer that. My initial choice would be I would probably just want to be called Spider-Man and have Spider-Man's powers because Spider-Man was always my absolute favorite growing up. From a practical standpoint, if I'm going to just pick based on a pre-existing superhero, um, I don't know. I tend to be very risk averse, so I'd probably pick, you know, I mean, Superman's kind of easy because he can do everything. Or Superman or Colossus or somebody that is essentially invulnerable, so that I don't have to worry about getting hurt, getting sick. I can just close my eyes and cross the street and not worry about the cars running into me and that sort of thing. Would probably be something good for my peace of mind. Although I think I know not everyone picks, but a lot of times people pick flight. That would be pretty fun too, and certainly an impressive party trick. But I don't know how practical it would be. For example, if I can fly, but I don't have super strength, that means I can't take anyone with me. I have to just fly by myself. And there's no way to bring anyone along. So I think I'd want maybe like a variety pack, or just Superman, so I can basically do everything. Kelly, we know Gary is a beekeeper in his free time. What's an interesting hobby of yours? Gary has more interesting hobbies than I do. He's a beekeeper. He scuba dives in caves, which I've told him is basically all of my nightmares combined. Maybe if you added bees into that would make it even worse, because I would be in the dark underwater in a confined space and getting stung. So I'm not going to sign up for that. Mine are a little bit more sedate, I guess. I collect vinyl records, which I really enjoy doing. The joke about it is that I really enjoy the expense and inconvenience of vinyl. Really what I like about it is I've always been kind of a collector. I have a preposterously large CD collection. I've always enjoyed going to record stores and finding things, and buying vinyl is a way that I can continue to enjoy the hunt for music now that I've got Spotify. I love streaming music. It's amazing to be able to have any song I want at my fingertips on my phone, basically by magic. I enjoy that and use it tremendously, but it does kind of lose that hunting experience that I enjoy. So that's a very big hobby of mine. Similarly, I read. I would say I read compulsively, and I read just about everything under the sun. And so those are kind of my big hobbies in the limited time I have when I'm not chasing my 3 and 1 year old around the house. Adam, interesting. You mentioned being disbarred as a result of some type of misconduct. Is that permanent, or are there circumstances where an attorney could eventually practice again? Adam, going back to the standard law school answer on things like this, it depends. Certain penalties result in disbarment. Certain penalties result in suspension. It often depends on the individual state. It depends on how the state enforcement works. Here in Missouri, we have a commission actually that they review complaints, and they adjudicate and decide if there's a penalty necessary. I believe in most states, if you are disbarred, there are certain avenues that you are able to apply for readmission. And they basically make you start over. And again, with the severity of the penalty, if you just tiptoe across the line that results in a disbarment, you are more likely to be able to successfully reapply than if you jump with both feet way over that line. But it really depends on the individual case. And so I think that under most circumstances, you are not necessarily precluded for life, but if it's a steep enough act that you engaged in, there basically eventually becomes no realistic opportunity of successfully reapplying. And so it's functionally for life, even if it isn't necessarily officially for life under those circumstances. So to my knowledge, Mike Nifong is not licensed to practice. I don't think, with something like that, I don't think he should ever be licensed again. Other circumstances in which I don't think you should ever be licensed again, it would be like stealing client money, or embezzling client funds, or manufacturing evidence in a case, and those kinds of things. I think under those circumstances, disbarment is entirely appropriate, because you've demonstrated under those circumstances that you shouldn't be in a court of law. And again, it goes back to trust. And you need to be, the joke is, trust me, I'm a lawyer, and everyone laughs. But while most people will say that they don't trust lawyers in general, if they have a lawyer, they're probably going to be quick to tell you that they trust their lawyer. And that's our goal, is to be that kind of a lawyer. And that's who we are, and that's what we do for our clients, is we represent them, and they can trust us to have their best interest at heart. And that's a lot of that. Actually, it's a big part of the reason I joined Burger Law. Was I knew Gary a little bit from prior work. I talked to some people about Gary, and they spoke incredibly highly of him, and about his litigation skill and the ability you have to trust Gary. And so I signed on for that, and that has absolutely been the case. Okay. Another general type question: do you ever represent people you don't like? I have. It happens occasionally. I like most people. I like to think most people like me. I can't say I like everybody. There's one client in particular that really jumps out in my mind, who told me to do an anatomically impossible act on the phone, and then hung up on me. And at the time, his insurance company was paying for me to represent him, so I was actually a free attorney. And I thought, if you treat your own attorney this way, I can't imagine how you're going to treat the other side's attorney. It can be an obstacle. And it's something that, but it's something that you can't let it impact your job. And if you continually butt heads with a client, you do have the opportunity to say to them, if you have such a problem with me, you could always get another attorney. I'm not the only attorney on the planet, but it's something that you don't always have to get along with somebody perfectly to work effectively with them. Sometimes when you read, if you're like I am, and you like reading all the nuts and bolts of how music gets made, and how bands function, or how movies get made, and how things are on set, or how art gets made in general, or how business deals come together, or how sports teams function. I very much enjoy insider stories like that. And a lot of times you'll find that the best work gets done when not everyone's getting along. A very famous example of it is Fleetwood Mac recorded what a lot of people believe is their best album, Rumors, while the two couples that were in the band were actually either getting divorced or separating. And they came up with what a lot of people view as their best work, despite all of that conflict. And so sometimes if you can harness it effectively, it can really work for you, but it'll come down to your personalities. Brennan, if you had to make a career change, what would you like to do? Well, of course, under no circumstances would I ever make a career change. I say that a little bit in jest, but I really do enjoy being an attorney. It's a hard job. It's difficult, but it's interesting. It's always different. You're always learning, which is probably my favorite thing about the job, is that you're continually in a position to learn new things, whether it's about a new product, whether it's about a new area of the law, whether it's about a new set of circumstances, a new location, a new career that your client may have that ends up mattering to your lawsuit if you're representing them on a workers' compensation claim or an injury claim. Oftentimes you have to learn a significant amount about their job, and I love that constant learning. I'd say if I was doing something else, actually, my dad worked in hotel restaurant management for a very large portion of his career, and for my entire life. He had a few other jobs before I was born that were outside of hotel and restaurant management, but I always really enjoyed his work from that standpoint because of some of the similar things, and that it's constantly a challenge. You're constantly learning. You're interacting with people very often, which I do enjoy, and you're doing something that brings people, in those cases, a very large amount of satisfaction, and that you're bringing them their dinner, or you're making sure that their vacation goes well. And so I would want to be probably in something like that, whether it would be managing a restaurant or managing a hotel or a resort or something like that, where you have something where there are a lot of different areas that you're working in, and you're using a lot of that varied knowledge that you pick up in order to do your job on a day-to-day basis. Okay, going to some other more general questions. If my kids and I are in a car accident, I get injured, can't work for a year, and there are other medical bills, what good is a settlement if I don't get one for 2 years? That is often a consideration in cases that we are representing people on, is whether, money now or money later. And often the question comes down to money now or potentially more money later. And that's why it's important to have effective communication with your clients. You want to understand what their interests are and what's going to best help them. There are circumstances where people can get loans against settlement proceeds, meaning that you basically borrow money and you give that person a right of recovery against your settlement. We generally discourage that kind of thing because it can potentially cause you problems down the road if you borrow too much against whatever you might end up recovering. But for example, to use that example, if you are in a catastrophic motor vehicle accident that's just extremely serious, and you have extraordinarily high hospital bills, you're going to be out of work for a long period of time, but it's a situation that maybe the other driver was driving an 18-wheeler and they're working for an over-the-road trucking company that has $10 million in coverage, and the other driver was definitely at fault, and there's a video showing that they fell asleep at the wheel and caused the accident and severely injured you. Under those situations, it would be easier for you to get a loan that would allow you to pay your monthly bills, your weekly bills, keep the lights on, keep the electricity and water on, and allow you to live on while the suit is pending, because you may need to have that suit pending for an extended period of time because of the severity. If it's a much less severe situation, and you're simply looking at getting your hospital bill paid for and getting some recovery for the pain and suffering that you had to deal with while you were recovering from maybe a broken wrist or a broken ankle or something like that, then you may want to see if you have an opportunity to settle. And very often we have luck settling cases before suit is even filed by communicating directly with the insurance company. Okay, another general type question: how easy or difficult is it for a lawyer to transition from one type of law practice to another? Again, you go back to the default. It depends. It depends on your personality. It depends on some of the background. I have changed several times, but all in areas that are at least related to each other. I had, early in my career, I got a good amount of experience on the defense side and representing insurance companies, doing what's called insurance coverage work, where you are doing policy interpretation, or sometimes you're doing, I was doing class action work or defending manufacturers and that sort of thing. And if you're in something that is at least somewhat related, for example, if you are doing contract work exclusively and you decide you want to go to business litigation because you want to change and be a litigator, that's going to be easier than going from estates and trusts and then suddenly becoming a prosecutor. It's not to say it can't be done, but it's going to be a little bit more challenging to make a larger transition. So if you can move at least into an area that is somewhat related, that does offer advantages. But I think generally having practiced in a different area of law can really be of help, because you bring a different perspective on things. And that's something that I've always kind of harped on. I've never liked the phrase outside the box thinking, because usually when people think of outside the box thinking, they always go to the same side outside the box. They have their one quote unquote outside the box position, but if they're always looking at the outside of the box from the same perspective, they may decide that, well, this is a red box because every time I step out of it, it looks red. But that's because they keep looking at it from the same perspective. And so if you have the opportunity to take a different perspective, you might realize that half the box is red and the other half of the box is blue. You just simply never looked at it from that perspective before. So I think that somebody who would maybe have like estates and trusts or property law experience, having that different kind of perspective on things can often be very helpful when you transition to another area of the law. That can be very useful and can be a benefit to you, especially if you work with a good team and if you have a good mentor who's able to help you learn what you don't know. Because one of the things I found, it's, you practice law and you practice medicine. And the reason you practice is because you never know everything. Anyone that tells you that they know everything either hasn't done it long enough or has probably been doing it too long, because continually we're learning new things. There are continually changes in the law that you need to learn about. There are continually different strategies at trial that you need to learn about. And you want to continue learning throughout your entire career to make sure that you bring everything that you possibly can to the table when you are representing your client. And so I think that it's useful to have that desire. And if you are looking for a single individual trait that's going to help carry you through in your legal career and help benefit your clients, it's that interest in continually learning. And that's something else I got from my dad. Actually, he's 80, quite frankly, and he still finds like new bands on YouTube to listen to and sends me. Earlier this week, he sent me something on YouTube that he'd found. And he's continually had that interest in learning new things, and so I would encourage you to find. To do that really in your own career, but in the law, that's especially helpful when we're often, we're so often dealing with something that walks through the door that's never quite exactly what we've seen before. You can have 500 rear-end auto accidents, and if I say a rear-end auto accident, you generally think of somebody being at a stop sign or a red light, stopped, and then somebody doesn't see the light, doesn't see the stop sign, doesn't see the stopped car in front of them, or they're distracted, they're on their phone, they're looking away, they're playing with the radio. But all 500 of those, despite the underlying fact pattern being similar, will be extremely different just based on the personalities of the individuals involved. Maybe it's a different attorney on the other side that you've met before. Maybe your client is a different personality than you've ever dealt with. Maybe the type of injury they've had is something that you've never seen before. or it's a different judge, it's a different venue, it's a different courthouse that you're in. And so it's extremely important to have that curiosity to go forward and continue to learn so that you will be prepared to be surprised, because you're going to continue to be surprised throughout your career. And if you're not, maybe it's time to hang up your spurs, because that's really what this job is about. It's what makes it interesting, and it's what makes it fun. And when it stops being fun, maybe you should start looking around. As Brennan asked, if you have to make a career change, maybe that's the time if it stops being fun. So thank you for everyone who is on here. It's greatly appreciated. I appreciate you joining me. I've been talking at you for an hour. So thank you very much. I hope you enjoyed it. I hope you found it interesting. Please join us next week and every week thereafter. We're here on Wednesdays at 3 o'clock. And thank you very much. Have a great day.